anything like that, a legal agreement at the outset is of the utmost importance. Agreeing on things while you get along is much easier than trying to agree on things when you don't like each other anymore. And of course, that'll never happen. But let's just say it might. If it happens, trying to agree on things becomes very difficult. It becomes adversarial. And a lot of times lawyers make a lot of money fighting over things. So the easier thing to do is to sit down. My advice would be, before you even start looking at properties, if you've decided this is a path you want to go down, a great exercise is to get all the parties interested in a room, sometimes a bottle of wine helps, and talk about exactly what it is that you're looking to accomplish, what everyone is bringing to the table, and what you're agreeing to. And people call me and they say, well, what do we need for the agreement? And what I tell them is this: just write out in plain language what you want the agreement to be. What are you agreeing to? We can take it from there. We can take a plain language bullet point, or sometimes people write more in prose, but a bullet point synopsis of the agreement that everyone is concurring with, and we can turn that into a legal co-ownership agreement or cohabitation agreement. And then if there's any areas that may not have been addressed, we can bring those up. So the main areas we're going to be looking at, and we'll go through them quickly one at a time, but the first one is ownership structure. Again, is it going to be a joint tenancy or a tenancy in common? We need to make sure everyone understands the implications. What are the rules for adding or changing owners, accommodating life changes? If you have a bunch of friends that are looking at buying a property, what happens if one of them becomes romantically intertwined with someone and they want to, get married? What happens if one of the individuals decides that they want to start creating a family? How does that impact it? What does that impact on the relationship here? Obviously, financial clarity is of the utmost importance. Who is bringing what to the table, and what impact does that have? The ongoing costs of the property. How are those going to be managed? If someone takes hour-long showers and the other person prefers a cold soak outside, should they be equally contributing towards the water bill? These are things that have to be considered. And lifestyles of people. You can be great friends, but living with someone is very different than being friends and going on a Mexican getaway once a year. So these are things that actually have to be thought of and addressed. I've actually seen it before, where a group of people who were thinking of that actually rented an Airbnb for 4 or 5 months trying to live together to see if that was something, to see whether or not that was something they actually thought would work for their lifestyles and how they individually live. If someone is a slob in the kitchen and the other person has a phobia when it comes to dirty dishes or something like that, how's that going to play out? So that brings us to the management and maintenance. Our responsibilities for the management, is that getting divided between individuals? Is there a rotating list? How are we doing that? Is there going to be a fund that's established, a joint bank account or something where we're going to pull expenses from? What about major repairs, upgrades, painting, things such as that? Are there going to be hard and fast rules? Is there going to be a curfew? Things like that again, people chuckle about, but these are things that if you have someone who works nights versus someone who works from home during the day, and maybe like this, they are giving a presentation and a person's trying to sleep in the next room, that may not jive together. These are things you have to take into account. So the usage rights. Does everybody have free reign over the entire property? Are there bedrooms which are going to be the exclusive use of individuals? What about friends coming over and staying over? Can you sublet? Does someone have a pet? Are there any going to be restrictions on bringing pets? What about noises? Can someone work from home? And does that impact, again, the usage as it compared to other people? I had one of these about 3 or 4 months ago in which it was a cottage. And there were a group of friends that were looking to buy a cottage. And we sat down together and we said, okay, how do we envision this working? And they all kind of looked at each other and they hadn't put any thought into it. And I said, well, is everyone allowed there every weekend? What happens if someone wants to bring other people up? And these are things that they had to go away and think about and come up with the idea to say, okay, over the course of the summer, each owner will have one exclusive use weekend or full week. And then there'll be a few weeks where they are essentially open for anyone and everyone who wants to come. And then they decided, I think it was 1 week, I think it was the August Civic Long Weekend, they called it kind of, the board meeting, I think, which they chuckled, they called it, and that where everybody there, the expectation was they would all get together there and, hopefully remind themselves why they decided to do this together. But individually, any of them being able, from what they told me, to afford the cost of a waterfront property, a cottage, and then the upkeep of it wasn't realistic, but this was one way they could do it and hopefully make it so that it would work for all of their families, because these are people who had families with that and wanted to have that type of lifestyle. How do we prevent disputes? Again, setting it out ahead of time, the rights and responsibilities. We want to reduce the potentials for misunderstanding. We want to address the issues before they arise. So we want to have the conversation when it's just awkward and it's not adversarial. When maybe we have to talk about the fact that, hey, Joe, when I've gone over to your house, it always seems like there's a ton of dishes in the sink. If we're going to be living together, that's just not. I can't deal with that. What are we going to do to make sure that doesn't happen? Are there going to be dispute resolution mechanisms? What do we do if a dispute arises? Are we going to go to mediation and bring in a dispute resolution expert on that? Or is there going to be, if there's multiple people involved, someone, if they're not involved, is going to be the decision maker, things such as that. In my experience, these ownership agreements and co-ownership or cohabitation agreements, if everyone's getting along, nobody looks at it. It's just there in the background. These become important when people stop getting along, because then we can go back and to refer to what exactly the responsibilities for everyone is. What about exit strategies? What happens if someone wants to sell or exit the agreement? Are there buyout options? Can they just sell to anyone, or is there a right of first refusal for the individuals? What happens if everyone agrees that there's a certain person that they just can't live with anymore? Is there a mechanism whereby a certain percentage can force someone out? How does that impact the financing if they've had to obtain financing for this? If you no longer have an individual who is going to be one of the owners there? Again, what happens if an individual develops a long-term romantic partner and they want to bring them into the property? Does that mean that they have to leave? Does that make changes to things? What are the exit strategies we're looking at? Can one person just pull the plug and say, no, that's it, this entire thing is over? Or is there a certain percentage of people that have to have it? What happens if someone passes away? Nobody likes talking about it, but it can happen. What happens with that ownership? Do we really want to be co-owners with someone in a will? Is that? So maybe do we have to do mechanisms like have insurance? I've seen circumstances before where people will actually have insurance on all the owners that is paid for from a collective pool to ensure that if one of them does pass away, the proceeds of that insurance will be sufficient so that the other ones can effectively pay out that amount to the beneficiary without having to bring in one of the beneficiaries or more as an owner. Regular reviews and updates are a great way of doing it so that we understand how things are progressing. Is there anything that's changing with respect to the way people are working together and living together? Does the agreement have to be updated? It's something that should be looked at on a regular basis.
Mike, how feasible is it? Like, there's so many important features here. How feasible would it be to have a lawyer such as yourself sit down and help lay this out initially? Or is it just so broad that it takes a while? Or is there a certain point?
So typically what we would say is this, let's say the main points are something that I think people are better served dealing with themselves, with or without the bottle of wine, and getting agreement on the main principle. What is everyone contributing? What does the ownership look like? And then if they present that to us, we can take that, we can turn it into, again, a cohabitation, co-ownership agreement. And then the areas that maybe weren't addressed by them, we can bring those to them and say, hey, what about X? What about B? What about J? And they can either go back and think about those together, or we can have everyone in a meeting. Obviously, the more involved the professionals are, the higher the bill, and it depends on how people want to do things. If they want the lawyer to quarterback it, that's fine, but there's a cost associated with that versus, again, sometimes, like I said before, a couple bottles of wine are cheaper. To sit in a room and do it yourselves and then get the main things down. Because if you don't have agreement on the main part, the rest of it's useless. Don't worry about the little things if you can't agree on the big things. Once you have the big things agreed to, again, present it to, the lawyers will look at it and say, okay, this makes sense, we can work with this. We'll then structure an agreement, normally put a draft, and then there'll normally be some questions in there. We always like NTD, note to draft, or question that we will pose, and then the individuals A lot of times we'll take it away and we'll talk about it and we'll think about it and we'll see what they come up with as to answers to things like that. To be honest with you, the process is not very much different than when we have people going into business together. And you're doing, whether it's a partnership agreement or a shareholders agreement, and it's the same, and the same issues are addressed. What can one person do without the agreement of the others? What do we need agreement from two people? What does it have to be unanimous on? What happens if we decide we don't want to be in business or live together? So from an approach standpoint, it's a lot of the same areas that are addressed, and a lot of times the same process that's used. This isn't something that's done in a day or a couple of days. This is something that takes a little bit of time. Does that help, Carol?
Absolutely. Thank you.
Perfect. So again, monitoring compliance. Do we have to have someone who's got to be the heavy? Nobody wants that. Is that what we need? Something like that? Does there have to be, you get an email or something saying, someone noted you doing this and that's against the rule? I mean, how are you going to enforce this, right? Without, driving everyone crazy. What happens if someone loses their job? What happens if their financial situation changes? How's that going to be done? These are things that have to be talked about, right? What happens again if someone, their situation changes? What happens if they get transferred? Depending on what type of job they do, they may not have any control over where they actually work from, and they may have to move or something like that. Or if they are someone that gets posted overseas, what happens then? These are things you need to take into account. Again, unauthorized alterations to the property, does it have to be returned? Future changes, who agrees to it? Again, neglect or maintenance responsibilities, violations of usage agreements. This is how it's enforced, right? So I mentioned earlier mediation and arbitration. A mediation, for those that aren't familiar with it, it's a mediator who facilitates a resolution. Let's call it kind of the peace train. They try to get everybody on the same board. Nothing is really enforced or anything like that. An arbitration is different than that, in that an arbitrator's decision is final and binding. Think of it as, going to court without the pomp and circumstance of going to court. It's kind of a quick and dirty way of a third party coming in and making a decision based on something. So mediation is a lot more, I'd say, conciliatory, and arbitration can be pretty adversarial. So if there's a serious breach or continuous non-compliance, what happens? Is there a buyout offer that's made? Do we have them? I mean, I've seen them once or twice in these. They are more prevalent sometimes in a business sense, but we have them before where they call it a shotgun clause, where one party will name a price, and then the other party gets to decide whether they sell or buy at that price. How does that impact financing? Again, the large thing, which Julie will talk about in a second here, the large kind of specter is that, institution that's lent you the money in most of these circumstances, and how are they going to treat someone leaving a disagreement or something like that? And those something that has to be think about it. For lack of a better term, you almost have to think of, if you're getting financing, your financial institution is almost another party to this agreement, where they always have to be kept in at least the back of your mind, if not the front of the mind, to what impacts we make here, what are they going to have on our relationship with our lender. And with that, I will turn it over to Julie, unless there's any questions, to talk about how the financing would act on.
Any questions for Mike? That was excellent, Mike. Julie, on to you, and then we'll see if there's any questions after that. And if you have any for Mike, or you want to put some in the chat box that you'd like to have addressed, just write it in there.
Julie, you may want to make sure everyone's awake after listening to me talk for that long.
Like you said, we're going to be tied for who's more boring, but I think we both got a handle on it. The slides kept me engaged, so thanks for that. I wanted to echo some of the sentiments just before I started. So working with Mike and Carol, one of the most important things that you can have when you're dealing with a real estate transaction or anything, but real estate in particular, is having a team on your side. And Mike and Carol have been amazing to work with because of that responsiveness, because of that team mentality. So if you're looking for people to work together, you really want to be selective, and Mike and Carol and Barb are wonderful to have on side there. I'm just going to move this out of the way. So I'm Julie Sheremeto. I'm a mortgage broker. And as Carol alluded to, I am split between two provinces. So I go back and forth between Ottawa and Kelowna. And they really both offer different things. The cities are wonderful, but I decided to get my license in both so that I've got the ability to help people in both places that I live. And it does mean that my work hours, although they were already a little bit crazy, are even more available to people. So if you have questions, don't hesitate to reach out, because I do try to keep on top of things like that. So my contact information is there, but that information will be shared around as well. My background, I was a high school math teacher for 15 years before I jumped into mortgages. So that gave me a little bit of the math side of things. But the one thing that I enjoy about both careers that I've been fortunate enough to hold is that I get to help people. And helping people and problem solving is what I enjoy doing. And moving over to mortgage brokering, I was able to continue doing that. So here to help if you need me. So Mike was talking about several of the considerations to make before you enter into an agreement with family or friends or whomever it is. The biggest piece from a financing perspective is who is actually going to be buying that home. So are you looking at parents co-signing with their children and everybody moving in together? Is it a situation where parents are purchasing to be able to assist with the financing or with the down payment, but they don't actually want to live there? Maybe they don't even want to own part of the home. As Mike mentioned, there can be considerations that occur later on when you're dealing with what kind of impact it has if that parent already owns a home and then they take on 100% ownership as joint tenants with their children. So biggest things to think about are who's going on the mortgage application and who's going on title, and are they going to live in the home together or are they just helping out? If we know who it is that's buying, then we need to start asking questions about how they're going to qualify for financing. So what is the employment status of all of the parties? Oftentimes, if it's parents that are purchasing with their children, parents are going to be retired and probably have a limited income stream. If there's no income there to support the application and perhaps they have accumulated a fair amount of liability, then that actually may be a detriment to that purchase application. Another thing is the age of the parties. So lenders tend to be a little bit more restrictive when it comes to issuing 25 or 30-year mortgages, depending on how old the applicants are. And it's not a matter of being discriminatory, but they really are looking for ways to make sure that loan gets repaid. That's their job, is to mitigate that risk. So we do need to consider the ages of all of the parties who are going on title and who are purchasing, including the younger side of things as well. Sometimes there's a number of children and they're looking to buy with their parents, and some of those children haven't reached the age of majority yet. Or one of them, I just had that happen last week. A 17-year-old, and then the other two kids wanted to go on with the parents. That doesn't fly because you can't have a minor entering into that purchase agreement. So we do have to consider employment, we have to consider age, and we also need to look at the credit establishment. The credit piece of it is as much of an important part of the financing approval as is the income qualification or the employment or retirement income. If there's not enough credit that's been established, or if there's no credit score reporting from the credit bureaus, or if there's a large number of debts that are being carried by any of those parties, that's going to impact the ability for that person to purchase and go on the mortgage application. And anybody who is on the mortgage needs to be on title. So needs to own part of that property in some way, shape, or form.
Let's say if there was somebody that it was a separation and it wasn't that individual that had the bad credit rating, but rather it was their spouse, ex-spouse. that had the bad credit rating. Mm-hmm. Would that still...
So are you looking at a situation where the one of those spouses is looking to buy a new home on their own?
With a group of people.
With a group of people. So at that point, if the ex-spouse, the one who has the poor credit, is not going to be on the mortgage or purchasing the home, then that spouse's credit rating doesn't impact anything. The ex-spouse's credit rating doesn't impact anything. But what will matter is if they've taken on joint debts together. So if they're co-signed, let's say on a car loan, and technically it's supposed to be the ex-spouse's responsibility, and they've missed a bunch of car payments, that's going to be reflected on the person who's trying to purchase and move out on their own. It's going to show as a missed payment on them because they're jointly signed for that credit. Does that make sense?
Yes, unfortunately.
Yes. So it's really important. So co-signing, we'll get to that as well, but co-signing, it really does matter what you're putting your name behind. Because even if it's a car loan or a credit card or anything at all, furniture, people go and buy furniture sometimes from Leon's or wherever, and they go on the Never Never plan. That when those come due, if you've co-signed and those payments are missed, that's going to reflect negatively on your own credit, as well as impact your ability to get future loans. So yes, that does matter. This is also for an important consideration for anybody who is new to Canada. So we do have several new to Canada programs that can take place in lieu of established credit. Oftentimes what we're seeing is that what I have been seeing, I would say, and like Mike mentioned, in the last couple of years, this is really where this has been starting to get some traction, and the interest level has increased, not just for friends, but we've had such a high level of immigration over the past few years, and the multi-generational living is one of the ways in which some of the new Canadians are getting home ownership, and they haven't had a chance to establish credit yet. So there are some ways to work with that as well. So as I mentioned, if an applicant goes on the mortgage, they also have to be on title. There are exceptions where there's something called a guarantor. So a guarantor is different than a cosigner. A guarantor means that they are telling the lender that they're going to help pay that loan if the person who's purchasing the home defaults. Lenders have steered away from guarantors a little bit in more recent history because they don't have any skin in the game. So if they're not going on title and they're not buying that home, then the lenders are a little bit less convinced that they're going to successfully get a mortgage payment out of the guarantor if the person who's buying it stops paying. They still are possible. So if you have parents that are looking to help their children and they don't actually want to have any ownership, we still have lenders that will consider making them a guarantor so that we can use their income for qualification. One of the things that most people don't realize is that typically mortgages are not issued to more than 4 individuals. So when you've got a group of 6, 7, or 8 people that are looking to buy, and commonly they don't even get that big, but I've had 5 in the last couple of years show up multiple times. We have a more restrictive list of lenders that will allow for more than 4 individuals. So there are considerations when you have larger groups. We need to be very particular with whether or not that particular mortgage application is going to fit with those lenders that allow for those larger applicants, larger number of applicants. And that's where some exceptions may apply. And then the relationship between the individuals is important, not only for what Mike was saying in terms of your future arrangements, for how you're going to deal with conflict, how you're going to deal with buying one another out, but from the lender's perspective, a parent-child mortgage is a lot more common and a lot easier for them to approve than simply friends purchasing together. So absolutely it's possible and has been happening more and more. The lenders are slowly starting to come around to that, but it has not been as popular of an opinion for them, or as popular of a choice for them to approve.
Are the rates a lot higher in those cases?
No, they're not. They're exactly the same product, exactly the same rates. We just need to make sure that we properly present to the lender what it is that's happening, how it's being managed, and again, it boils down to risk. Every lender is looking at their risk portfolio for what's the likelihood this mortgage isn't going to get repaid. So when they're approving a mortgage application, first it has to fit all of the regular guidelines for income and debt servicing and all of the things that we do for any mortgage. But then the next piece is, does it fit all of the criteria where they're going to be comfortable moving forward? And I have had to do a little bit of mitigation around that in the past, which is, I think, going to become less and less of a problem moving forward, because we are seeing it more and more, but just where the balance lies right now, we need to be cognizant of it and make sure that we've got that agreement that's been outlined, presented to the lender as well as part of this. This was the New to Canada component I was mentioning. So there have been many enhancements for New to Canada programs, and that's going to assist with getting more Canadians into homes and into home ownership. The one thing that is a little bit of a misnomer is that you need to have 20% down payment in order to purchase. If you are new to Canada, you can still buy with as little as 5% down payment. And a portion, in some cases, all of the down payment can actually be gifted. It does need to be gifted from an immediate family member. And I will talk a little bit about some of the options for if parents don't want to buy with their children or don't want to move in with their children, but they still want to assist them, the down payment can be gifted. So from an immediate family member is okay. Building credit is extremely important. The one exception that we have is that if a Canadian resident has been here less than 5 years, then we can use alternative forms of credit. So we can look at hydro bills, we can look at their cell phone payments, we can look at rental agreements, lease agreements, and rent payments. And all of that can be used to supplement, but also replace anything that's reporting to the credit bureaus from Equifax or TransUnion. And it's simply because it takes years to develop credit through those credit bureau facilities. So if there's a situation like that, we can certainly review it. And then we have residency status that also needs to be considered. So permanent resident status, they should be able to purchase without any restrictions, just going back to that credit component. So PR, not a problem. Work permits are going to be dependent on how much time is left on their work permit, and so what's the expiry date of it, and whether or not they are the spouse of somebody who is a permanent resident as well, because that will preclude that. So lots of options for multi-generational and New to Canada programs. Gifted down payment, as I mentioned, needs to be from an immediate family member. So your second cousin twice removed, it does not, the lenders do not view that as being an immediate family member.
Mike, I have a question for Mike in here. Is it common for that down payment gift to be used almost as an advance from parents on their estate, like to one of their children?
So how the down payment is characterized, Carol, is that what you're...
Yes, and is it fairly common, and are there difficulties with it?
On our end, there isn't, because that's kind of Julie's bailiwick. By the time it gets to us, I always joke, I don't care how you get the money to me, I just need the money. But there are some banks, and I think Julie can say, I mean, I had a question this morning when I was meeting with people, because there's a gift from parents. And they're like, can we send you the money directly, or do we have to send it to our kids who are the buyers to send to you? And I said, I don't know. I said, check with your mortgage professional, because, Julie, correct me if I'm wrong, there are some lenders who want to see that money in the borrower, in this case, the kid's account, coming to us. They don't want it directly from that because, A, they don't have a relationship with them. That is, a mechanism where if they can't see it, everyone's always worried about fraud, right? And this is a concern where they're worried about where's the money coming from. So they want to see that the borrower buyers have it. So my supposition is that it should probably go directly to them. Most times they're going to want to see a gift letter, which is a pretty straightforward, I hereby give, $1 million to our kids or something like that. But that really is done in what's called the underwriting stage, and that's really where Julie excels. That's where your mortgage professionals kind of dot all the I's and cross all the T's so that they get that final approval, and that's when they send everything to us. So both of us will have our list of requirements, but that's typically one of them that Julie's going to see. Just quickly, when it comes to people under a work permit, and this may not apply to anyone, but just in case it does, yes, under the ban that Canada has enacted, people on a work permit can buy a property, but Ontario did not remove the applicability of the non-resident speculation tax. So yeah, you could, but you might have to pay Uncle Doug 25% of the gross sale proceeds for the right to do so. So just bear that in mind, because that does preclude pretty much everything.
If they have a spouse who is a permanent resident, are they still subject to that?
No. Anytime you have a spouse who's a Canadian or a citizen or a permanent resident, they don't even have to be on a work permit. As long as one of them, and in this case, when we say spouse, that does include common law. Common law is 3 years. A lot of people think it's one. Common law is 3 years. Or a child together in a relationship with some degree of permanence. But let's just say 3 years. So it has to be 3 years, or they're legally married. But yes, as long as the spouse is a citizen or permanent resident, then the citizenship status of the other individual doesn't matter.
Yeah, that's a really good point about the tax. There's a fairly hefty charge for that. And Carol, I will talk about the gifted down payment from an estate shortly, or an early inheritance kind of thing. But to answer the question about paper trail, it is essential that the gifted down payment portion be actually received by the children or by the buyers, whatever the relationship is, and that documentation is provided to the lender so that they can see that the down payment is available in the buyer's account and accompanied by that gift letter that Mike was mentioning. So those are the two typical requirements for gifted down payment. It does have to go through the buyer and needs to be approved by the lender. And that is for, and unfortunately, we have to say it, that it's the state of affairs, but anti-money laundering and mortgage fraud are two big concerns on the lenders' minds. And it's fairly prevalent. So they do all of their checks and balances to make sure it's coming from the right people to the right people and then being used for the right purpose. It's also the reason we need so many documents, and it feels a little bit like document fatigue. It doesn't feel like it. It is document fatigue for a lot of people, but we can't have redacted bank statements or anything like that for those reasons as well. In terms of income, I mentioned the sources of income can be from employment income. It can be government pensions, so CPP and OAS are acceptable. We can also use employer pensions. And if you have a situation where somebody's retired and they've been drawing on retirement income, RIF income, then as long as there's a 2-year history of that, it can be applied towards mortgage qualification. So this is from a mortgage qualification perspective. And then from the endpoint perspective, as Mike mentioned, we've got some considerations to make about how that equity is going to be divided in the home, in addition to all of your other exit strategies and how you're going to manage things along the way. You need to know who's getting what out of the house when this ultimately comes to an end. in whatever way. Before I change slides, I did want to mention too, Mike had mentioned insurance, and this is something I don't have on my slides, but the one tool that can be a really great asset to add into this is mortgage protection plan. It's something that we actually legally have to offer on every mortgage application, provided, even if depending on eligibility, but mortgage protection plan is offered through Manulife, and it does provide a life insurance policy for anybody that's taking it, and that will pay out the mortgage balance in the event that the insured person were to pass away. So it's not like a term policy where there's a certain amount of money that gets allocated to the beneficiary. It is simply to pay the mortgage balance off. So this is something that those entering into these the shared ownership structure may wish to consider, just so that it's purely for the purpose of paying the mortgage off. They also offer a disability option, which will cover up to 2 years of mortgage payments and property taxes if the person that's insured becomes disabled. But that's just an aside about the mortgage insurance option to cover that asset off, or the liability off towards the asset, I should say.
We have a question in, Julie, about how long it takes to be audited for a mortgage, and I think it means to how long
to be
qualified, I'm guessing.
To be qualified, yeah. So the process itself is not actually very, very long. The application form is about a 15-minute application form, just filling in the information for anybody that's looking to apply for the mortgage together. The longest, or I guess probably the most cumbersome part, is getting the supporting documents to go with it so that we can verify income, we can verify down payment, and we can go through all those checks and balances. That's on the borrower side of things. Once we have all of that information, we can give you a pre-approval within a day or two by reviewing all of that information. So the turnaround time on a pre-approval can be very quick. And then once you enter into an accepted purchase situation, so you get an accepted offer on a home, then we would have a discussion about which lender, which product, which term, which type, all of the things that go with the mortgage selection. And the lenders usually take 3 to 5 business days to get back to us with a firm approval on a specific property as the other side of the timeline. I hope that answers that question, but let me know if not. I wanted to mention, in terms of joint tenancy and tenants in common. So joint tenancy, as Mike said, it's viewed as 100% ownership. And so if you end up with a parent who is a joint tenant with their child, for example, then that parent presumably they wouldn't have another home of their own. If they're not going to be living with that child, and they just want to help them out by going on the mortgage and then going on title, that's where what Mike was saying about that sort of setting it up like a tenants in common, so there's a percentage ownership by each party, can be beneficial. The one piece on the financing side to go with that is that not all lenders allow for tenants in common relationships. Some will require joint tenancy, and so that is something that we would want to be really clear on before we make the choice of lender, which we wouldn't make until you've got an accepted offer on a purchase. But a consideration nonetheless, sort of like having more than 4 people on title. It's just something we need to know ahead of time so that we can choose wisely. Yes, okay, spoke about that. That's great. Let's switch my screen. And then this is what I think you were sort of mentioning, Carol, is that how common is it for parents to be assisting with a purchase without necessarily wanting to live together? That's that early inheritance piece. And we see it, I would see it on probably 40% of my first-time home buyer purchase applications where there is some sort of gifted down payment from a parent. And that can be, or cosign, I guess there's both that happen. The key thing is when a parent is taking money out of an investment in order to assist, it may not be the best use of funds. So one of the more common options right now is for people to take a reverse mortgage, for the parents to take a reverse mortgage. And they've fell out of favor because of a lot of misinformation that was coming out of the US about people taking reverse mortgages and then the bank owning their home and taking their home from them and things like that. We have a very, very different structure for reverse mortgages in Canada. And if you're over the age of 55, if you have a fair amount of equity in your property, you should be able to tap into some of that equity through a reverse mortgage, which might preclude the need to draw, say, $200,000 from an investment that's got a 7, 5, 6, 7% return on it. That allows you to give what is effectively a living inheritance. The nice thing about doing a gifted down payment, if a parent is looking to assist, is they may not want to have anything to do with the new mortgage, or they may not wish to buy. Even if they're going to live in the property, they may want to just say, please have this, take this money for now, and let's just leave it like that. Just it's a bit of a cleaner division for people. So you don't have to be co-signing, you don't have to worry about the implications of coming off title in the event of somebody passing away, or what those dissolution options look like. And like I said, it may also avoid the need of drawing out high return investments too soon by putting a reverse mortgage on. So lots of options for ways that people can buy, finance, and live together, but also options for how parents can assist children if they're looking to do so without actually entering into those agreements or entering into the living arrangement. This is a very common option for people who are trying to help their children buy a home with a suite that eventually they may want to move into. And that's ultimately the plan, but they're not ready to yet. This is one of the ways that can be facilitated. I think I've covered everything off that's on this slide, but knowing that what the relationships of the parties is ahead of time so that we can choose the lender properly, knowing what the arrangement is going to be with the joint tenancy versus tenants in common so that we can choose the lender ahead of time. All of those pieces are important. Getting a pre-approval is the way to ensure that you have had your file reviewed by a professional. You want to make sure all of the intricacies, the ins and outs of your potential purchase are structured in a way that's favorable to you. And it also gives you time to talk to a lawyer and talk to Mike and see what you might have forgotten or what else might need to be considered in that arrangement.
If you have a child in or a relationship with somebody else in another province, how does that work in terms of, now I know, Julie, you could operate in Ontario and in BC. Mike?
We're restricted to Ontario. So if it would depend, I mean, you're looking at what the governing law is. It obviously varies province to province, let alone if you're looking at, kind of other countries. Generally, you're going to look at the governing legislation and you want it to be governed by whatever province that the property in question is going to be. So you would reach out to kind of a lawyer, or we can connect you with someone in one of those different jurisdictions.
Okay.
The other thing to bear in mind as well is we do have to put in context who the parties are, as Julie said, but it's important because there may be a family law component to it. And family law is a very, very specialized area of law, and I have phenomenal professionals who can assist with that. But in the circumstance in which there is a family law component, in the circumstance, again, of parents of one of a kind of romantic partners providing a large chunk, them wanting, again, we call it a cohabitation agreement, a marriage contract, some people call it prenup, to make sure that their investment or what they're giving is protected in the case of a marriage breakdown. We would get some of those professionals involved to make sure that we are not we're not discounting, we're not ignoring, but we are taking into account the very, very, very specific and specialized considerations from a family law perspective.
Thank you. Julie, anything else to add on that?
No, I think that's it. The cohabitation agreement can be for even for an unequal contribution to down payment. For example, if you want to know, like, one person's got a spouse that, if that relationship ends, they don't want their $200,000 that they gave to their son or daughter to be necessarily just taken over by the spouse. So those agreements can be drawn up for a number of different situations. But the out of province piece is, I can do Ontario and BC, and like Mike said, we have people across the country that if you're in a different province and it falls outside of my jurisdiction, for example, then we have arrangements to help out with that.
Okay.
Yeah. And then the last thing was just, I wanted to make a note. Mike had mentioned when somebody's leaving that arrangement, if you've got a parent on title or you've got a spouse and it's set up as, however it's set up going into it, and a friend of a spouse, when somebody leaves and comes off of the title for the home, they also have to come off of the mortgage. And in doing so, the remaining people have to qualify to carry that mortgage on their own. Doesn't necessarily mean that a change needs to be made to the mortgage, so you don't have to break the mortgage to make that change, but you do need the lender to requalify the remaining applicant or applicants and make sure that they qualify on their own to do so. And then it's the legal side of things from there. So you don't have to break the mortgage, but they do have to qualify if they're remaining on the mortgage and somebody leaves. And I think that's it.
Thank you very much. We have another question here. What about houses with a tiny home for parents at the back? And Ottawa, of course, is going in pushing for this to become more common. How do the legalities on that and the financing work?
Well, from a legality point of view, you want to make sure, obviously, that it was constructed with, the proper building permits, or it's permitted by the city, the relevant bylaws. So, if you're looking and you're buying a property that has one of these tiny homes, or, kind of whatever you want to call it, you want to make sure you do your due diligence to ensure that it is properly there, the city's aware of it, and that it complies with everything there. If you are looking to do one, same thing, you have to go through the process with the city to ensure that they will have a record of it. You're kind of meeting all the requirements they have for it.
And from a financing perspective, it is not ideal because lenders typically do not consider the value of any outbuildings when they are determining the value that they're going to lend against. So it depends on the size of the loan that's required and the value and the purchase price, because if too high of an amount is looking to be mortgaged against the value, it probably won't be supported, because when you buy the home, there would be value inherent to the fact that there's another building on there, sort of like it's treated like a garage, a secondary garage or a work shed or something like that. So for the buyer, there's value, but to the lender, it's just the value of the main building that they consider and the value of the land for their loan.
Okay.
I have a quick question for Mike. With the tenants in common, when one party passes away, is it important to change the ownership on title to the estate of blah, 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 the estate of John Smith or whatever? Is that like a must do, or is it a recommended to do that? Is it, particularly when there's a bit of like contentious energy?
It needs to be done, but before that can be done, they have to go through, what we colloquially call the probate process.
Yeah.
The official terminology is a certificate of appointment of an estate trustee with or without a will. Once you get that, then you're going to do the transmission application, which transfers the ownership of that particular share if they have other owners, and it's going to go to the estate trustee or trustees, or what we call the executor or executors, are going to be listed, but they're listed as trustees on behalf of the estate.
Okay.
So it's going to be transferred there. I mean, it's not something that has to be done immediately, but it's something that does have to be taken into account and done, because, the estate for legal purposes is an entity just like a person or a corporation is. So the estate has the ability to contract, and the executor or executors are the ones who can contract. So yes, that should happen. It's not something you need to do kind of the next day, but it's something that we need to do as part of the estate administration process.
Okay, thank you.
Thank you. So any more questions before we close off? I can't thank the two of you enough. This has been so informative, and I think it really shows it shows who you are too as professionals, and I like that and appreciate it very much. Because this is such an important direction, I think that we're going in terms of home ownership and families living together and friends living together. We're kind of going back in time, and I think it's going to continue. We want to make this into a series where we will be having a subsequent seminar with ones that have gone through the process, and so I'm lining that up, and because more the social end of it and how to make it work. And we're going to be doing follow-up. Julie will be contacting you with some information, just contact information there. Mike will give information there too for you to be able to just contact and let ones know if they have any questions for you. And also, I had said that we were going to be recording this. Well, I have no idea what happened, but that did not kind of happen. We will be.
Carol, because I have in the